Question 1. The audit findings indicate that a significant number of rescued horses at an Alabama equine rescue facility were transferred to new owners during the past fiscal year. During a review of transfer records, it was noted that while all horses were physically moved to new locations, the documentation for several transfers was incomplete, with some prospective adopters' suitability not being fully assessed beyond a brief conversation. What is the most ethically and legally sound approach for the rescue organization to adopt moving forward to ensure compliance with Alabama's equine rescue and rehabilitation laws? Option A. Prioritize transferring horses to individuals or entities with existing equine experience, without conducting further background checks or verifying their current living conditions, as their past experience is presumed to guarantee future responsible ownership. Option B. Expedite the transfer process for all rescued horses to new homes as quickly as possible, focusing primarily on finding any willing recipient to reduce the burden on the rescue facility, and completing paperwork only as a secondary concern. Option C. Rely on verbal assurances from prospective adopters regarding their experience and ability to care for the horses, and only complete the most basic transfer forms, assuming that the horses will be well cared for. Option D. Implement a standardized, multi-stage adoption process that includes thorough vetting of prospective adopters, verification of their ability to provide adequate care, and meticulous completion of all legally required transfer documentation according to Alabama statutes. The correct answer is D. Implement a standardized, multi-stage adoption process that includes thorough vetting of prospective adopters, verification of their ability to provide adequate care, and meticulous completion of all legally required transfer documentation according to Alabama statutes. Explanation: the audit findings indicate a potential lapse in adherence to Alabama's equine rescue and rehabilitation laws, specifically concerning the responsible transfer of rescued animals. This scenario is professionally challenging because it requires balancing the immediate need to rehome animals with the long-term welfare and legal obligations associated with their transfer. A veterinarian or rescue organization representative must exercise careful judgment to ensure all legal requirements are met, protecting both the animals and the organization from liability. The best professional approach involves diligently verifying the suitability of the prospective adopter and ensuring all documentation is complete and accurate according to Alabama law before finalizing the transfer. This includes confirming the adopter's capacity to provide appropriate care, housing, and veterinary attention, and completing all required transfer forms that accurately reflect the animal's condition and history. This approach is correct because it directly aligns with the spirit and letter of Alabama's equine rescue and rehabilitation laws, which prioritize the welfare of rescued animals by ensuring they are placed in capable and responsible homes. It also mitigates legal risks for the rescue organization by demonstrating due diligence and compliance with transfer protocols. An approach that prioritizes speed of placement over thorough vetting of the adopter is professionally unacceptable. This failure would violate Alabama's equine rescue and rehabilitation laws by potentially placing an animal in an unsuitable environment, thereby jeopardizing its welfare and potentially leading to neglect or abuse. Such an action could result in legal repercussions for the rescue organization, including fines or loss of operating privileges. Another unacceptable approach is to omit or falsify information on the transfer documentation. This directly contravenes Alabama's legal requirements for record-keeping and transparency in animal transfers. It undermines the integrity of the rescue process and prevents proper tracking of the animal's history, which is crucial for its ongoing care and for accountability. Finally, an approach that assumes the adopter's competence without any verification, or that relies solely on verbal assurances, is also professionally unsound. Alabama's laws implicitly require a level of due diligence to ensure the animal's future well-being. Failing to conduct reasonable checks exposes the animal to risk and leaves the rescue organization vulnerable to claims of negligence. Professionals should employ a decision-making framework that begins with a thorough understanding of the specific requirements of Alabama's equine rescue and rehabilitation laws. This involves consulting the relevant statutes and guidelines regarding animal transfer, adoption criteria, and documentation. When faced with a transfer scenario, professionals should systematically assess the adopter's qualifications, review all necessary paperwork, and ensure all legal obligations are met before proceeding. If any aspect of the transfer raises concerns or falls outside the established legal parameters, the professional should pause the process, seek clarification, or consult with legal counsel if necessary, prioritizing the animal's welfare and legal compliance above all else. Question 2. The audit findings indicate a recent incident at an Alabama equine facility where a rider fell from a horse during a training session. The horse, a seasoned jumper, appeared to stumble. The rider sustained minor injuries and is concerned about the horse's condition and potential contributing factors. As the attending veterinarian, what is the most appropriate course of action to address the situation ethically and in compliance with Alabama's legal framework governing equine activities? Option A. Document the incident in the horse's record as a minor stumble and proceed with routine care without further investigation or communication regarding the fall. Option B. Conduct a thorough veterinary examination of the horse to assess for any physical or medical issues that may have contributed to the stumble and communicate findings to the rider and stable owner, advising on any implications for the horse's immediate and future riding suitability. Option C. Advise the rider to immediately resume normal training with the horse, assuming the horse is not showing obvious signs of distress, and focus solely on the horse's immediate comfort. Option D. Recommend that the rider simply rest and recover, and that the horse be given a few days off without a veterinary assessment, as the fall was likely due to rider error. The correct answer is B. Conduct a thorough veterinary examination of the horse to assess for any physical or medical issues that may have contributed to the stumble, and communicate findings to the rider and stable owner, advising on any implications for the horse's immediate and future riding suitability. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent risks associated with equine activities and the potential for injury. The veterinarian's duty of care extends beyond immediate medical treatment to ensuring the safety of all parties involved, including the rider and any spectators. Alabama law, specifically the Alabama Equine Activities Act, aims to limit liability for equine professionals, but does not absolve them of responsibility for gross negligence or intentional misconduct. The veterinarian must balance their professional obligations to the horse with the legal and ethical considerations of the rider's safety and the facility's compliance with safety standards. Correct approach analysis. The best professional approach involves a comprehensive assessment that prioritizes the horse's immediate well-being, while also addressing the safety concerns raised by the rider's fall. This includes a thorough veterinary examination of the horse to rule out any underlying medical conditions that could have contributed to the fall, such as lameness, neurological issues, or colic. Simultaneously, the veterinarian should communicate their findings to the rider and the stable owner, advising on any potential risks to the horse's future performance or suitability for riding. This approach aligns with the veterinarian's ethical duty to both animal and human welfare, and acknowledges the legal framework by not ignoring potential contributing factors that could be relevant under the Alabama Equine Activities Act, particularly if the fall was due to a pre-existing, undiagnosed condition. Incorrect approaches analysis. Recommending immediate return to strenuous activity without a thorough examination fails to uphold the veterinarian's duty of care to the horse. It risks exacerbating an underlying injury and could lead to further harm, potentially exposing the veterinarian to liability beyond the scope of the Equine Activities Act. Ignoring the rider's concerns and focusing solely on the horse's perceived recovery is ethically problematic and demonstrates a disregard for the interconnectedness of equine activities. This approach neglects the potential for the horse's condition to have contributed to the rider's fall, which could have implications under Alabama law if negligence is alleged. Suggesting the rider was solely at fault without a veterinary assessment of the horse is premature and unprofessional. The veterinarian's role is to provide an objective medical opinion on the horse, not to assign blame for the incident. This bypasses the necessary veterinary due diligence and could lead to an inaccurate assessment of the situation, potentially misrepresenting the facts if legal proceedings were to arise. Professional reasoning. Professionals in equine practice should adopt a systematic approach when faced with incidents involving rider falls. This involves a multifaceted assessment that considers the health of the animal, the safety of the rider, and the operational integrity of the facility. A thorough veterinary examination is paramount to identify any medical factors contributing to the incident. Open and clear communication with all involved parties, including the rider and the facility owner, is essential. Professionals must be aware of the relevant legal framework, such as the Alabama Equine Activities Act, and understand that while it provides certain protections, it does not excuse gross negligence or a failure to exercise reasonable care. Decision-making should be guided by ethical principles of animal welfare and human safety, supported by sound veterinary judgment and an understanding of applicable laws. Question 3. The audit findings indicate that Dr. Anya Sharma, a veterinarian in Montgomery, Alabama, has been treating a valuable show horse for a chronic lameness issue. The horse's owner, who is facing financial difficulties, has expressed a desire to sell the horse. Dr. Sharma, who has a personal interest in acquiring horses for resale, believes she can manage the horse's condition and potentially profit from its sale. What is the most ethically and professionally sound course of action for Dr. Sharma in this situation, adhering to Alabama equine law and veterinary ethics? Option A. Continue to treat the horse and wait for the owner to initiate discussions about selling the horse, at which point she can then disclose her interest and offer to purchase it. Option B. Advise the owner to sell the horse quickly at a reduced price to a third party, without disclosing her own intention to potentially purchase it later or her assessment of its true market value. Option C. Proceed with managing the horse's lameness and advise the owner on the best course of treatment, without mentioning her personal interest in buying the horse, assuming she can manage its condition effectively. Option D. Immediately disclose her personal interest in purchasing the horse to the owner and recommend an independent veterinary evaluation of the horse's condition and prognosis before any sale is considered. The correct answer is D. Immediately disclose her personal interest in purchasing the horse to the owner and recommend an independent veterinary evaluation of the horse's condition and prognosis before any sale is considered. Explanation. The audit findings indicate a potential conflict of interest and a breach of fiduciary duty, making this scenario professionally challenging. The veterinarian's dual role as both the treating veterinarian and a potential beneficiary of the horse's sale creates a significant ethical dilemma. Careful judgment is required to ensure the horse's welfare, and the client's best interests are prioritized above personal gain. The best professional approach involves immediately disclosing the potential conflict of interest to the client and recommending an independent veterinary evaluation. This approach is correct because it upholds the core ethical principles of veterinary medicine in Alabama, which emphasize client trust, transparency, and the avoidance of situations that could compromise professional judgment. Alabama Veterinary Practice Acts and ethical guidelines, such as those promoted by the Alabama State Board of Veterinary Medical Examiners, mandate that veterinarians act in the best interest of their patients and clients. By recommending an independent evaluation, the veterinarian demonstrates a commitment to objective care and avoids any appearance of impropriety, thereby protecting the client's financial interests and the horse's health. An approach that involves proceeding with the sale without full disclosure and relying solely on one's own assessment of the horse's condition is professionally unacceptable. This fails to meet the ethical obligation of transparency and could be construed as self-dealing, violating the trust placed in the veterinarian by the client. Such an action could lead to a violation of Alabama veterinary regulations concerning professional conduct and conflicts of interest, potentially resulting in disciplinary action. Another unacceptable approach is to advise the client to sell the horse at a lower price to a third party without disclosing the veterinarian's personal interest in acquiring the horse. This misrepresents the horse's true market value and exploits the client's trust for personal financial benefit. It directly contravenes the ethical duty to provide honest and unbiased advice, and it could expose the veterinarian to legal liability for misrepresentation or breach of fiduciary duty under Alabama law. Finally, an approach that involves delaying the disclosure of the conflict until after the sale has been finalized is also professionally unacceptable. This constitutes a deliberate withholding of crucial information that would have influenced the client's decision-making process. It represents a significant ethical failure and a violation of the veterinarian's duty to act with integrity and honesty throughout the professional relationship. Professionals should employ a decision-making framework that prioritizes transparency, client welfare, and adherence to regulatory and ethical standards. When a potential conflict of interest arises, the immediate steps should be to identify the conflict, assess its potential impact, and communicate openly and honestly with the client, offering solutions that safeguard their interests and maintain professional integrity. Question 4. Strategic planning requires a veterinarian in Alabama to assess a horse's condition and discuss treatment options with its owner. If the owner expresses significant financial limitations, what is the most ethically and legally sound approach for the veterinarian to take regarding a potentially expensive, experimental treatment versus standard care or euthanasia? Option A. Delay further diagnostics and treatment recommendations until the owner can secure additional funds, without clearly outlining the potential negative consequences of such a delay on the horse's health and prognosis. Option B. Proceed with the experimental treatment if the veterinarian believes it has a high chance of success, as the owner has brought the horse for veterinary care and implicitly trusts the veterinarian's judgment, even if the full financial implications and risks are not exhaustively detailed. Option C. Fully disclose all risks, benefits, costs, and prognoses of both the experimental treatment and standard care options. Explore all financially viable alternatives, and obtain explicit informed consent from the owner before proceeding with any course of action, prioritizing the horse's welfare within the owner's stated financial constraints. Option D. Recommend euthanasia immediately if the owner indicates financial hardship, to avoid further escalating costs and potential suffering for the horse, without thoroughly exploring all treatable options. The correct answer is C. Fully disclose all risks, benefits, costs, and prognoses of both the experimental treatment and standard care options. Explore all financially viable alternatives, and obtain explicit informed consent from the owner before proceeding with any course of action, prioritizing the horse's welfare within the owner's stated financial constraints. Explanation: this scenario is professionally challenging because it involves a potential conflict of interest and requires careful judgment to ensure compliance with Alabama equine law and ethical professional conduct. The veterinarian must navigate the delicate balance between client relationships, financial considerations, and the welfare of the animal, all within the specific legal framework of Alabama. The best professional approach involves prioritizing the horse's welfare and adhering strictly to the Alabama Equine Activities Act and relevant veterinary practice regulations. This means obtaining informed consent for any proposed treatment, clearly outlining the risks, benefits, and costs, and documenting all discussions and decisions thoroughly. Transparency regarding the horse's prognosis and the financial implications of treatment is paramount. This approach aligns with the veterinarian's ethical duty of care and legal obligations to act in the best interest of the animal while maintaining a clear and honest relationship with the owner. An approach that involves proceeding with a costly, experimental treatment without explicit, informed consent from the owner, based solely on the veterinarian's personal belief in its efficacy, is professionally unacceptable. This failure to obtain informed consent violates the owner's right to make decisions about their property and the animal's care, and potentially exposes the veterinarian to liability under Alabama law for unauthorized treatment. Furthermore, recommending an unproven, expensive treatment without full disclosure of alternatives and success rates could be considered a breach of ethical veterinary practice. Another professionally unacceptable approach is to recommend euthanasia solely based on the owner's financial concerns, without a thorough, objective assessment of the horse's prognosis and potential for recovery with standard, less expensive treatments. While financial considerations are a reality, a veterinarian's primary duty is to the animal's welfare. Recommending euthanasia prematurely, without exploring all viable medical options and discussing them transparently with the owner, could be seen as a failure to meet the standard of care and could have legal ramifications if the horse's condition was treatable. Finally, an approach that involves delaying treatment and further diagnostics due to the owner's expressed financial limitations without offering alternative, more affordable diagnostic or treatment pathways, or without clearly documenting the risks of delay, is also professionally unsound. This inaction, driven by a perceived financial barrier without proactive problem solving, could lead to the horse's condition worsening, increasing future costs, and potentially compromising its welfare. It fails to uphold the veterinarian's responsibility to provide timely and appropriate care within the owner's stated constraints, necessitating a discussion of all available options. Professionals should employ a decision-making framework that begins with a comprehensive assessment of the animal's condition, followed by a transparent discussion with the owner about all diagnostic and treatment options, including their respective risks, benefits, costs, and prognoses. This dialogue should be documented, and informed consent obtained before any procedures are undertaken. If financial constraints are a significant factor, the veterinarian should proactively explore and present all feasible alternatives, ensuring the owner is empowered to make informed decisions that balance the animal's welfare with their financial realities, all within the bounds of Alabama equine law. Question 5. Compliance review shows that a buyer in Alabama has purchased an equine for a significant sum, and shortly after the sale, the horse exhibits a serious, pre-existing health condition that was not disclosed by the seller. The buyer wishes to return the horse and receive a full refund. What is the most appropriate course of action for the buyer's legal representative to advise, considering Alabama's regulatory framework for equine transactions and animal welfare? Option A. Advise the buyer to meticulously review the sales contract for any clauses related to warranties, representations, or remedies for undisclosed conditions, and to consult with an attorney specializing in Alabama equine law to assess potential claims for breach of contract, misrepresentation, or fraud under Alabama statutes, while simultaneously exploring options for the horse's immediate care. Option B. Advise the buyer to immediately return the horse to the seller and demand a full refund, citing the horse's poor health as justification, without further legal consultation. Option C. Advise the buyer to accept the horse's condition as a risk of purchasing livestock and to focus on managing the horse's ongoing veterinary care, foregoing any attempt to seek recourse from the seller. Option D. Advise the buyer to file a lawsuit against the seller for breach of contract and fraud, seeking immediate repossession of the horse and a full refund, without first attempting any form of negotiation or dispute resolution. The correct answer is A. Advise the buyer to meticulously review the sales contract for any clauses related to warranties, representations, or remedies for undisclosed conditions, and to consult with an attorney specializing in Alabama equine law to assess potential claims for breach of contract, misrepresentation, or fraud under Alabama statutes, while simultaneously exploring options for the horse's immediate care. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of how Alabama's specific equine laws interact with general property and contract principles, particularly when dealing with a potentially distressed animal and differing stakeholder interests. The core challenge lies in balancing the immediate welfare of the horse with the legal rights and obligations of the parties involved, all within the framework of Alabama statutes. Careful judgment is required to avoid actions that could lead to legal liability or further harm to the animal. The best professional approach involves a thorough review of the existing sales contract and relevant Alabama statutes governing equine sales and animal welfare. This includes identifying any express warranties, implied warranties, or specific remedies available under Alabama law for breach of contract or misrepresentation concerning the horse's health. Consulting with legal counsel specializing in Alabama equine law is crucial to interpret the contract's terms and the applicability of statutes like the Alabama Equine Activity Liability Act or any specific provisions related to the sale of livestock, ensuring that any proposed resolution is legally sound and protects the client's interests while prioritizing the horse's well-being. This approach directly addresses the legal framework and stakeholder rights. An approach that focuses solely on the buyer's immediate desire to return the horse without a comprehensive legal review is professionally unacceptable. This fails to consider the seller's contractual rights and potential defenses under Alabama law, potentially leading to a breach of contract claim against the buyer. It also overlooks the possibility of negotiated solutions or alternative dispute resolution mechanisms that might be more efficient and legally compliant. Another professionally unacceptable approach is to immediately initiate legal action without attempting to understand the full contractual obligations or exploring less adversarial resolutions. This can escalate the situation unnecessarily, incur significant legal costs, and may not be the most effective way to achieve a favorable outcome for the client or the horse, especially if the contract provides for specific dispute resolution processes. Furthermore, an approach that prioritizes the seller's desire to retain the purchase price without acknowledging potential contractual breaches or the horse's welfare concerns is ethically and legally problematic. Alabama law, like most jurisdictions, provides remedies for buyers when goods are not as represented, and ignoring these can lead to legal repercussions and damage professional reputation. The professional decision-making process for similar situations should involve 1. understanding the client's objectives and the immediate situation. 2. Conducting a thorough review of all relevant documentation, including contracts and any supporting evidence. 3. Identifying the applicable legal framework, in this case, Alabama Equine and Contract Law. 4. Consulting with legal experts to interpret the law and advise on potential courses of action. 5. Evaluating the risks and benefits of each potential resolution, considering both legal and ethical implications. 6. Communicating clearly with the client about the options and recommending the most legally sound and ethically responsible path forward. Question 6. Operational review demonstrates that a seller in Alabama is preparing to list a horse for sale. The seller informs you, the professional facilitator, that the horse has a history of a suspensory ligament issue that has been managed but not fully resolved. The seller expresses concern that disclosing this information might significantly reduce the horse's sale price or deter potential buyers. The seller asks for your advice on how to proceed with the sale in Alabama, specifically regarding the disclosure of this pre-existing condition. Which of the following represents the most appropriate professional guidance for the seller in this Alabama equine transaction? Option A. Advise the seller to wait until the final stages of negotiation or after a sale agreement is signed to disclose the suspensory ligament issue, framing it as a recent development or a minor concern that has been addressed. Option B. Advise the seller that full disclosure of the suspensory ligament issue is legally required under Alabama law, as it is a material fact that could affect the horse's value and suitability for certain disciplines, and that failure to disclose could lead to claims of fraud or misrepresentation. Option C. Recommend that the seller describe the suspensory ligament issue as a minor, easily managed tendon strain without providing further details to avoid alarming potential buyers. Option D. Suggest the seller omit mentioning the suspensory ligament issue unless the buyer specifically asks about past injuries or medical history, as the seller is not obligated to volunteer information not explicitly requested. The correct answer is B. Advise the seller that full disclosure of the suspensory ligament issue is legally required under Alabama law, as it is a material fact that could affect the horse's value and suitability for certain disciplines, and that failure to disclose could lead to claims of fraud or misrepresentation. Explanation: this scenario is professionally challenging because it involves a potential conflict between a seller's desire to complete a sale and the ethical and legal obligation to disclose material facts. The professional must navigate the nuances of Alabama equine law concerning fraud and misrepresentation, balancing the seller's interests with the buyer's right to accurate information. Failure to do so could lead to legal repercussions for the seller and reputational damage for the professional. The best professional approach involves advising the seller that full disclosure of the pre-existing suspensory ligament issue is legally required under Alabama law, even if it might negatively impact the sale price or timeline. This approach aligns with the principles of honesty and transparency fundamental to preventing fraud and misrepresentation. Alabama law, like general principles of contract law, requires disclosure of material defects that a buyer would reasonably want to know, and that could affect the horse's value or suitability for its intended purpose. Concealing such a defect, even if not explicitly asked about, can constitute fraudulent misrepresentation or omission. Ethically, professionals are bound to uphold the integrity of transactions and avoid facilitating deceptive practices. An approach that suggests omitting the information about the suspensory ligament issue because the buyer did not specifically inquire about past injuries is professionally unacceptable. This fails to meet the legal standard of disclosure for material defects and opens the seller and the professional to claims of fraudulent misrepresentation by omission. Alabama law does not require a buyer to ask about every possible ailment. Sellers have an affirmative duty to disclose known material issues. Another professionally unacceptable approach is to advise the seller to downplay the severity of the suspensory ligament issue without providing full details. This borders on active misrepresentation. While the seller might not be outright lying, they would be creating a misleading impression, which can be legally actionable as misrepresentation. The intent is to deceive the buyer into believing the issue is less significant than it is, thereby influencing their decision to purchase. Finally, advising the seller to wait for the buyer to ask specific questions about the horse's past medical history before disclosing the suspensory ligament issue is also professionally unsound. This strategy relies on the buyer's potential lack of knowledge or specific questioning, which is not a defense against fraud or misrepresentation. It attempts to shift the burden of discovery onto the buyer, rather than fulfilling the seller's duty of proactive disclosure of known material defects under Alabama law. Professionals should employ a decision-making framework that prioritizes legal compliance and ethical conduct. This involves thoroughly understanding the relevant Alabama equine laws regarding disclosure and misrepresentation. When faced with a situation where a seller wishes to withhold or downplay material information, the professional's duty is to educate the seller on their legal obligations and the potential consequences of non-disclosure. The professional should clearly articulate that facilitating a transaction based on incomplete or misleading information is unethical and illegal, and that full and honest disclosure, even if it impacts the sale, is the only professionally responsible course of action. Question 7. Cost-benefit analysis shows that a horse owner, distressed by mounting veterinary bills and the horse's slow recovery from a severe injury, is requesting immediate euthanasia. As a veterinarian practicing in Alabama, what is the most ethically and legally sound course of action to take? Option A. Proceed with euthanasia based on the owner's emotional distress and stated financial concerns, without conducting a detailed medical assessment. Maintain a positive client relationship. Option B. Refuse to consider euthanasia, insisting the owner pursue all possible, albeit expensive, treatment options regardless of the horse's prognosis, to avoid any appearance of condoning the owner's financial concerns. Option C. Conduct a thorough veterinary examination to assess the horse's current condition, prognosis, and potential for recovery, document all findings, and then discuss the medical realities and options, including humane euthanasia, with the owner. Option D. Immediately agree to the owner's request for euthanasia to alleviate their financial burden and emotional distress, as the owner is the legal custodian of the animal. Correct answer is C. Conduct a thorough veterinary examination to assess the horse's current condition, prognosis, and potential for recovery, document all findings, and then discuss the medical realities and options, including humane euthanasia, with the owner. Explanation. This scenario is professionally challenging because it involves balancing the immediate financial needs of a horse owner with the long-term welfare of the equine and the potential for future disputes. Alabama equine law, while not as extensive as some other areas of law, emphasizes principles of good faith, reasonable care, and the prevention of cruelty. A veterinarian's professional judgment must navigate these principles, particularly when dealing with a distressed owner facing difficult decisions. The correct approach involves a thorough, objective assessment of the horse's condition and prognosis, documented meticulously and communicated clearly and empathetically to the owner. This approach prioritizes the animal's welfare by ensuring decisions are based on medical necessity and the best available information, aligning with Alabama's general principles of animal welfare and the veterinarian's ethical obligations. It also protects the veterinarian by establishing a clear record of professional conduct and informed consent, mitigating future liability. An incorrect approach would be to immediately agree to the owner's request for euthanasia without a comprehensive veterinary evaluation. This fails to uphold the veterinarian's duty of care to the animal, potentially leading to unnecessary suffering or premature death, which could be viewed as a violation of general animal welfare principles in Alabama. Furthermore, proceeding without a thorough assessment and documentation leaves the veterinarian vulnerable to accusations of negligence or malpractice, should the owner later dispute the decision, or if the horse's condition was misjudged. Another incorrect approach is to dismiss the owner's concerns and refuse to consider euthanasia, even if the horse is clearly suffering and has no reasonable hope of recovery. This demonstrates a lack of empathy and professional judgment, potentially prolonging the animal's suffering and damaging the veterinarian-client relationship. While the veterinarian's primary duty is to the animal, a failure to consider humane euthanasia when medically indicated is also an ethical failure. Finally, an incorrect approach is to perform euthanasia based solely on the owner's emotional distress without a sound medical basis. While compassion is important, the decision must be grounded in the horse's physical condition and prognosis. Performing euthanasia for non-medical reasons, even with a distressed owner, can be ethically problematic and may not align with the spirit of Alabama's animal welfare statutes, which generally focus on preventing cruelty and ensuring humane treatment. Professionals should employ a decision-making framework that begins with a comprehensive medical assessment, followed by open and honest communication with the owner about the findings, prognosis, and available treatment options, including humane euthanasia. This process should be thoroughly documented, ensuring all parties are informed and that decisions are made in the best interest of the animal's welfare, consistent with ethical veterinary practice and applicable Alabama law. Question 8. Strategic planning requires a thorough understanding of the legal landscape. When advising a client on the care and management of their horses in Alabama, which approach best reflects the historical development of equine law in the state and its impact on current practices? Option A. Researching Alabama statutes and case law chronologically to understand how the legal treatment of horses has evolved from early property law principles to modern animal welfare considerations. Option B. Relying exclusively on the oldest Alabama statutes that defined horses solely as personal property, as these form the foundational legal basis. Option C. Focusing solely on the most recent Alabama legislation concerning animal cruelty, disregarding older statutes and case law. Option D. Applying general principles of animal welfare law commonly found in other U.S. states, assuming Alabama's laws are similar. The correct answer is A. Researching Alabama statutes and case law chronologically to understand how the legal treatment of horses has evolved from early property law principles to modern animal welfare considerations. Explanation. This scenario is professionally challenging because it requires understanding how historical legal precedents and evolving societal views on animal welfare have shaped current equine law in Alabama. A nuanced understanding is needed to advise clients effectively, balancing traditional property rights with modern ethical considerations. Careful judgment is required to navigate the potential for conflicting interpretations of historical laws and their application to contemporary equine practices. The best professional approach involves researching and understanding the historical evolution of equine law in Alabama, specifically examining how early statutes and common law principles, which often treated horses primarily as chattel property, have been modified by subsequent legislation and judicial interpretations, reflecting increased emphasis on animal welfare. This approach is correct because it grounds advice in the actual legal trajectory of Alabama, acknowledging both the historical roots and the progressive changes that define the current legal landscape. Adherence to this historical context ensures that advice is legally sound and ethically responsible, aligning with the principles of responsible animal ownership and care that are increasingly embedded in Alabama's legal framework. An incorrect approach would be to solely rely on the earliest historical statutes that viewed horses purely as personal property, ignoring subsequent legislative amendments and judicial decisions that have introduced protections and responsibilities related to animal welfare. This failure to acknowledge legal evolution risks providing outdated and potentially harmful advice, violating ethical obligations to clients and the animals themselves. Another incorrect approach would be to apply general principles of animal welfare law from other states or jurisdictions without verifying their specific adoption or adaptation within Alabama's legal system. Alabama's equine law has its own distinct development, and assuming universality of welfare standards can lead to misinterpretations and noncompliance with specific Alabama statutes and case law. Finally, an incorrect approach would be to dismiss the historical development of equine law as irrelevant and focus only on the most recent legislation. While recent laws are crucial, understanding the historical context can reveal underlying principles and the rationale behind current regulations, providing a more comprehensive and robust basis for legal advice. Ignoring history can lead to a superficial understanding and an inability to anticipate how existing laws might be interpreted in light of their past. Professionals should employ a decision-making process that begins with identifying the specific legal question or client need. This should be followed by a thorough review of Alabama's statutory law and relevant case precedents, paying close attention to the chronological development of these legal sources. Understanding the historical context allows for a more accurate assessment of the current legal standing and potential future interpretations, ensuring advice is both legally compliant and ethically sound. Question 9. The monitoring system demonstrates that a dispute has arisen concerning the sale of a prize-winning show jumper. The buyer, a resident of Georgia, claims the horse was misrepresented regarding its health and training history. The seller, an Alabama resident, argues the horse was sold as is, and that the buyer had ample opportunity to inspect. The contract was negotiated and signed via email, with the final agreement being electronically transmitted between Georgia and Alabama. The horse is currently located at the seller's stable in Alabama. The buyer wishes to pursue legal action in Alabama. Which of the following approaches best addresses the jurisdictional requirements for the buyer to file suit in Alabama? Option A. File suit in an Alabama state court solely based on the fact that the horse is currently located in Alabama, without further analysis of the contract's negotiation or the seller's domicile. Option B. File suit in a federal court in Georgia, assuming that because the buyer resides in Georgia, federal courts there would have jurisdiction over the dispute. Option C. File suit in an Alabama state court, arguing that the seller's residency, the location of the horse, and the execution of the contract through electronic means involving Alabama establish sufficient minimum contacts for Alabama courts to exercise personal jurisdiction. Option D. File suit in a federal court in a state unrelated to either Georgia or Alabama, hoping that the broad reach of federal courts will encompass the dispute. The correct answer is C. File suit in an Alabama state court, arguing that the seller's residency, the location of the horse, and the execution of the contract through electronic means involving Alabama establish sufficient minimum contacts for Alabama courts to exercise personal jurisdiction. Explanation: this scenario is professionally challenging because it involves navigating the complexities of interstate commerce and potential conflicts of law when an equine transaction spans across state lines, specifically involving Alabama. Determining the correct jurisdiction for legal recourse is paramount to ensuring a valid and enforceable outcome. A failure to correctly identify the governing jurisdiction can lead to wasted resources, dismissal of a claim, and ultimately, a denial of justice for the aggrieved party. Careful judgment is required to analyze the factual nexus of the dispute and apply the relevant Alabama and federal legal principles governing jurisdiction. The best approach involves a thorough analysis of the factual circumstances to establish the strongest connection to Alabama's legal system. This includes examining where the contract was negotiated and executed, where the horse was located at the time of the dispute, where the alleged breach occurred, and the residency or principal place of business of the parties involved. If these factors, or a significant combination thereof, point to Alabama, then filing suit in an Alabama state court or federal court sitting in Alabama would be appropriate. This aligns with Alabama's long-arm statutes and the constitutional due process requirements for establishing personal jurisdiction over a defendant. The Alabama Rules of Civil Procedure, particularly Rule 4, govern the exercise of personal jurisdiction, and courts will consider whether the defendant has sufficient minimum contacts with Alabama such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. An incorrect approach would be to assume jurisdiction solely based on the location of the horse at the time of the sale, without considering other significant contacts. While the horse's location is a factor, it may not be dispositive if the contract negotiations, payment, and other crucial elements occurred elsewhere, and the defendant has no other substantial ties to Alabama. This could lead to a challenge to jurisdiction based on lack of minimum contacts. Another incorrect approach would be to file suit in a state where the defendant resides, but has no other significant connection to the transaction or the dispute. While the defendant's residence might establish jurisdiction in their home state, it does not automatically confer jurisdiction in Alabama if the dispute's nexus is primarily elsewhere, or vice versa. This could result in the case being dismissed for lack of personal jurisdiction in Alabama, forcing the plaintiff to refile in the correct forum. A further incorrect approach would be to file suit in federal court in a state entirely unrelated to the transaction or the parties, without any basis for diversity jurisdiction or federal question jurisdiction. This would be a clear misapplication of federal court rules and would likely result in an immediate dismissal for lack of subject matter jurisdiction. The professional decision-making process for similar situations should begin with a comprehensive factual investigation. This should be followed by a careful review of Alabama's long-arm statute and relevant case law interpreting due process requirements for personal jurisdiction. Consideration should also be given to the potential for federal court jurisdiction, either through diversity of citizenship or a federal question, though in most equine disputes, state court jurisdiction is more common. Consulting with legal counsel experienced in Alabama equine law and civil procedure is crucial to ensure the correct forum is chosen. Question 10. Regulatory review indicates that for the purposes of a dispute resolution under Alabama equine law, the market value of a horse must be determined. A horse, a 7-year-old registered quarter horse mare, was purchased by its current owner 5 years ago for $15,000. The owner has invested $3,000 in veterinary care and $2,000 in training over the past 5 years. The cost to breed and raise a similar horse to its current age is estimated by a breeder to be $18,000. Based on current market conditions for similar horses in Alabama, including pedigree, health, and recent sales data, a qualified equine appraiser has determined the horse's fair sale price to be $12,500. Which of the following represents the most appropriate calculation of the horse's market value for this dispute resolution? Option A, the original purchase price, which is $15,000. Option B, the fair sale price determined by the qualified equine appraiser, which is $12,500. Option C, the original purchase price plus all invested costs, totaling $20,000, $15,000 plus $3,000 plus $2,000. Option D, the estimated cost to breed and raise a similar horse, which is $18,000. Correct answer is B, the fair sale price determined by the qualified equine appraiser, which is $12,500. Explanation: scenario analysis. This scenario presents a professional challenge due to the potential for financial loss and the need to accurately assess the value of a horse for a specific legal purpose. Misinterpreting the definition of market value or applying incorrect valuation methods can lead to significant disputes, legal challenges, and financial repercussions for all parties involved. The requirement for a specific calculation based on Alabama law necessitates precise adherence to statutory definitions. Correct approach analysis. The best professional practice involves calculating the horse's market value by considering its fair sale price between a willing buyer and a willing seller, neither being under compulsion to buy or sell, and both having reasonable knowledge of relevant facts. This aligns with the general principles of valuation and is the most direct interpretation of market value as understood in commercial transactions and often codified in legal contexts. Specifically for Alabama, this would involve a thorough assessment of the horse's breed, age, training, health, pedigree, and current market demand for similar horses. The calculation would then synthesize these factors into a justifiable price. Incorrect approach is analysis. One incorrect approach involves solely relying on the horse's purchase price from several years prior. This fails to account for market fluctuations, depreciation, or any improvements or detriments to the horse's condition or marketability since the original purchase. Alabama law, like most jurisdictions, recognizes that market value is a dynamic concept, not a static historical figure. Another incorrect approach is to base the valuation solely on the cost of breeding and raising the horse. While these are factors that contribute to a horse's potential value, they do not directly represent the price it would command in an open market sale. The cost of production does not equate to market value, which is determined by what a buyer is willing to pay. A further incorrect approach is to use a valuation method that is not recognized or applicable to equine assets, such as a depreciated book value used for business equipment. Equine assets have unique valuation drivers related to their biological nature, performance potential, and market demand, which are distinct from tangible business assets. This method would ignore the specific characteristics that determine an equine's market worth in Alabama. Professional reasoning. Professionals should approach valuation tasks by first identifying the specific legal or contractual definition of the value required, e.g., market value, fair market value, replacement cost. They must then research and apply the relevant statutory and case law of the governing jurisdiction, in this case, Alabama. This involves understanding how Alabama courts and statutes define and interpret key valuation terms. A comprehensive assessment of all relevant factors influencing the asset's worth, followed by the application of appropriate valuation methodologies, is crucial. Documentation of the valuation process, including all data and assumptions, is essential for defensibility. Question 11. Performance analysis shows a client in Alabama is seeking to understand the legal implications of selling a horse. Considering the specific regulatory framework of Alabama, Which approach best reflects the legal status of a horse in property law for the purpose of a sales transaction? Option A. A horse is a unique, non-fungible chattel with no specific legal classification beyond general personal property, requiring only basic contract principles for its sale. Option B. A horse is primarily considered a service provider, and its legal status is determined by the contractual agreement for its services rather than property law. Option C. A horse is legally classified as personal property, specifically livestock under Alabama law, and its sale is governed by statutes applicable to such property. Option D. A horse is legally equivalent to real estate, and its sale must adhere to the stringent requirements for land transactions in Alabama. The correct answer is C. A horse is legally classified as personal property, specifically livestock under Alabama law, and its sale is governed by statutes applicable to such property. Explanation: scenario analysis. This scenario presents a professional challenge because it requires navigating the intersection of property law and the specific legal status of equines in Alabama. Misunderstanding the legal classification of a horse can lead to significant financial and legal repercussions for all parties involved, including potential disputes over ownership, liability, and the enforceability of agreements. Careful judgment is required to ensure compliance with Alabama statutes governing livestock and property. Correct approach analysis. The best professional approach involves recognizing that, under Alabama law, horses are generally classified as personal property, specifically livestock. This classification dictates how they are treated in transactions, disputes, and legal proceedings. Understanding this fundamental legal status is crucial for correctly advising clients on issues such as sales, leases, liens, and liability for the animal's actions. This approach aligns with Alabama Code Title III, Agriculture and Animals, and Title VII, Uniform Commercial Code, which govern the sale and security interests in personal property, including livestock. Incorrect approach is analysis. Treating a horse solely as a service provider without acknowledging its property status is an ethical and legal failure. While a horse provides services, its fundamental legal standing in Alabama is that of personal property. This oversight would lead to incorrect advice regarding ownership rights, the ability to place liens, or the enforceability of sales contracts under Alabama law. Viewing a horse as a unique, non-fungible asset akin to real estate, without considering its classification as personal property, is also problematic. Horses possess individual characteristics. Alabama law categorizes them under personal property statutes, not real property. This misclassification would result in applying incorrect legal principles to transactions and disputes, potentially invalidating agreements or claims. Considering a horse as a mere chattel with no specific legal considerations beyond general personal property is an oversimplification that can lead to professional errors. While it is personal property, Alabama law, particularly concerning livestock, may have specific provisions related to branding, registration, or liability that are not covered by general chattel law. Failing to consider these specific livestock provisions can result in incomplete or incorrect legal counsel. Professional reasoning. Professionals should first identify the governing jurisdiction, Alabama. Then, they must determine the specific legal classification of the asset in question, a horse, within that jurisdiction's statutory framework. This involves consulting relevant Alabama code sections pertaining to agriculture, animals, and property. Once the legal status is established, professionals can then apply the appropriate legal principles and advise clients on transactions, disputes, and liabilities, ensuring full compliance with Alabama law. Question 12. The audit findings indicate a veterinarian in Alabama performed artificial insemination on a mare without obtaining a signed consent form, relying instead on a verbal agreement from the individual who presented the horse for breeding. What is the most appropriate course of action for the veterinarian to take moving forward to ensure regulatory compliance and professional integrity? Option A. Discontinue offering artificial insemination services altogether to avoid any potential future compliance issues. Option B. Continue to rely on verbal consent for artificial insemination procedures, assuming that individuals presenting horses for breeding have the owner's implicit authorization. Option C. Immediately implement a policy requiring all artificial insemination procedures to be preceded by a detailed, written consent form signed by the verified legal owner of the mare, and review all past records to identify any similar instances for potential follow-up. Option D. Seek to obtain a written statement from the individual who provided verbal consent, acknowledging their request for the procedure without verifying their ownership status. Correct answer is C. Immediately implement a policy requiring all artificial insemination procedures to be preceded by a detailed written consent form signed by the verified legal owner of the mare, and review all past records to identify any similar instances for potential follow-up. Explanation: the audit findings indicate a potential lapse in compliance regarding the documentation and consent requirements for artificial insemination procedures involving equine in Alabama. This scenario is professionally challenging because it requires a veterinarian to balance the immediate needs of animal reproduction with strict adherence to state regulations and ethical considerations concerning ownership and consent. Misinterpreting or neglecting these requirements can lead to legal repercussions, disputes between horse owners, and damage to the veterinarian's professional reputation. Careful judgment is required to ensure all parties' rights are protected and that the procedures are conducted within the legal framework of Alabama. The best professional practice involves obtaining explicit, written consent from the legal owner of the mare prior to initiating any artificial insemination procedure. This consent form should clearly outline the procedure, the risks involved, the identity of the stallion, if known, and the responsibilities of each party. This approach is correct because Alabama Equine Law, while not explicitly detailing AI consent forms in a single statute, operates under general principles of Veterinary Practice Acts and contract law. Veterinary Practice Acts mandate that licensed veterinarians act in the best interest of the animal and its owner, which includes ensuring informed consent. Furthermore, contract law principles require clear agreement between parties for services rendered. Documenting consent protects the veterinarian by demonstrating due diligence and adherence to professional standards, and it clarifies expectations and responsibilities for all involved parties, thereby preventing potential disputes over ownership of offspring or breeding rights. An approach that relies solely on verbal consent from an individual who may not be the legal owner of the mare is professionally unacceptable. This fails to meet the requirement for informed consent, as verbal agreements are difficult to prove and can be easily misunderstood or disputed. It also violates the principle of acting only with the authorization of the legal owner, potentially leading to disputes over ownership of the resulting foal and legal action against the veterinarian. Proceeding with artificial insemination, based on the assumption that a person managing the mare has the authority to consent without verifying legal ownership, is also professionally unacceptable. This bypasses the critical step of confirming the consenting party's legal standing, exposing the veterinarian to liability if the manager lacks actual authority. It disregards the fundamental requirement to obtain consent from the rightful owner. Finally, performing artificial insemination without any documented consent, even if the individual requesting it claims to be the owner, is professionally unacceptable. This represents a significant departure from standard veterinary practice and regulatory expectations. It leaves the veterinarian without any evidence of authorization, making them vulnerable to claims of unauthorized procedures, ownership disputes, and potential disciplinary action from the Alabama State Board of Veterinary Medical Examiners for failing to uphold professional standards and protect client interests. Professionals should employ a decision-making framework that prioritizes clear, documented consent from the verified legal owner of the animal. This involves a proactive approach to verifying ownership, utilizing comprehensive written consent forms that detail all aspects of the procedure, and maintaining meticulous records. When in doubt about ownership or consent, seeking clarification or legal advice is paramount before proceeding with any reproductive services. Question 13. Stakeholder feedback indicates that sellers in Alabama are sometimes unclear about their obligations when selling an equine. A seller knows their horse has a history of mild, intermittent colic that has been managed with diet and medication, and that the horse has a scar on its hind leg from an old injury that does not currently affect its performance. The seller has provided a written bill of sale that includes a general warranty of title, but no specific clauses regarding the horse's health or condition. What is the most appropriate course of action for the seller regarding disclosure of these known conditions? Option A. Provide the buyer with a separate, detailed written disclosure statement outlining the history of colic and the presence and origin of the scar on the hind leg, in addition to the bill of sale. Option B. Disclose only the intermittent colic, as it is a health-related issue, and omit mention of the scar, considering it a cosmetic issue that does not impact the horse's function. Option C. Assume that since the colic is intermittent and the scar does not affect performance, these are not material defects and do not require specific disclosure beyond the general bill of sale. Option D. Verbally inform the buyer about the colic history and the scar during a pre-sale conversation, assuming the buyer will ask questions if they are concerned. The correct answer is A. Provide the buyer with a separate, detailed written disclosure statement outlining the history of colic and the presence and origin of the scar on the hind leg, in addition to the bill of sale. Explanation. This scenario is professionally challenging because it requires a seller to balance their desire to complete a sale with their legal and ethical obligations to disclose known material defects. Failure to do so can lead to significant legal repercussions, including rescission of the sale, damages, and reputational harm. The core of the challenge lies in interpreting what constitutes a material defect and ensuring the disclosure is both accurate and timely. The best professional approach involves proactively and comprehensively disclosing all known material defects in writing. This approach aligns with Alabama's equine sales disclosure requirements, which emphasize transparency and the buyer's right to be informed about the horse's condition. By providing a detailed written disclosure, the seller creates a clear record of what was communicated, minimizing ambiguity and potential disputes. This proactive disclosure demonstrates good faith and adherence to legal obligations, protecting both parties by setting clear expectations. An incorrect approach would be to only verbally mention a known issue, such as a past lameness, without documenting it. This fails to meet the spirit and likely the letter of disclosure laws, which often require written statements. Verbal disclosures are difficult to prove and can be easily misinterpreted or forgotten, leaving the seller vulnerable to claims of misrepresentation or concealment. Another incorrect approach is to assume the buyer will discover a defect through their own inspection and therefore not disclose it. While buyers have a responsibility to conduct due diligence, sellers have an affirmative duty to disclose known material defects. Relying on the buyer's discovery does not absolve the seller of their legal obligation and can be seen as an attempt to mislead. Finally, an incorrect approach is to disclose only minor issues while omitting significant ones. This selective disclosure is deceptive. Material defects are those that could reasonably affect the horse's value, suitability for its intended purpose, or the buyer's decision to purchase. Omitting such information, even if other issues are disclosed, constitutes a failure to meet the disclosure requirements. Professionals should approach such situations by first understanding the specific disclosure requirements under Alabama law for equine sales. They should then meticulously document all known conditions, past injuries, and any other information that could be considered a material defect. This documentation should be provided to the potential buyer in writing before the sale is finalized. If there is any doubt about whether a condition is material, it is always safer to disclose it. Question 14. The audit findings indicate a potential issue with the title transfer of a registered quarter horse mare in Alabama. The seller has provided a bill of sale, but it appears to be missing the buyer's full address, and the sale price is listed as negotiated. The buyer is eager to complete the registration process with the Alabama Department of Agriculture and Industries. What is the most appropriate course of action to ensure regulatory compliance? Option A. Accept the bill of sale as is and inform the buyer that the missing information will be addressed at a later date if issues arise. Option B. Request a revised bill of sale from the seller that includes the buyer's complete address and a clearly stated sale price, and verify that this revised document aligns with any existing registration information for the mare. Option C. Advise the buyer to proceed with registration based on their verbal confirmation of ownership from the seller, as a bill of sale is often a formality. Option D. Proceed with the registration using the provided bill of sale, assuming the buyer's address is implicitly known and the negotiated price is acceptable for record-keeping purposes. The correct answer is B. Request a revised bill of sale from the seller that includes the buyer's complete address and a clearly stated sale price, and verify that this revised document aligns with any existing registration information for the mare. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a potential discrepancy in the documented ownership of a valuable equine asset, which can lead to significant legal and financial complications. Ensuring accurate and legally sound title transfer is paramount to protecting the interests of all parties involved, and maintaining the integrity of equine ownership records in Alabama. Careful judgment is required to navigate the specific requirements of Alabama equine law regarding title documentation and registration. Correct approach analysis. The best professional practice involves meticulously reviewing all provided documentation for completeness and accuracy against the requirements of the Alabama Department of Agriculture and Industries, specifically concerning equine bill of sale and registration. This approach prioritizes adherence to the established legal framework for title transfer in Alabama, ensuring that the transfer is legally recognized and properly recorded. By verifying that the bill of sale contains all legally mandated information, such as the names and addresses of buyer and seller, a clear description of the equine, the sale price, and signatures, and that it aligns with any existing registration documents, the professional safeguards against future disputes and ensures compliance with Alabama statutes governing equine sales and ownership. Incorrect approach is analysis. One incorrect approach involves accepting the bill of sale at face value without verifying its completeness or cross-referencing it with any existing registration documents. This failure to perform due diligence can result in an incomplete or invalid title transfer, leaving the buyer vulnerable to ownership claims from third parties and potentially violating Alabama's record-keeping requirements for equine transactions. Another incorrect approach is to proceed with registration based solely on the buyer's verbal assurance that the seller is the rightful owner, without any supporting documentation. This bypasses the fundamental legal requirement for documented proof of ownership transfer, which is essential for establishing a clear chain of title under Alabama law. Such an action could lead to fraudulent registration and significant legal repercussions. A further incorrect approach is to assume that a bill of sale is sufficient for title transfer without confirming if Alabama law requires additional steps, such as notarization or specific witness requirements for equine transactions. Relying on assumptions rather than established legal procedures can render the transfer legally deficient and expose the parties to legal challenges. Professional reasoning. Professionals in Alabama dealing with equine title transfers should adopt a systematic approach. First, identify the specific legal requirements for equine bill of sale and registration under Alabama law. Second, meticulously examine all submitted documentation for compliance with these requirements, paying close attention to details like signatures, dates, descriptions, and consideration. Third, cross-reference information between the bill of sale and any existing registration documents to ensure consistency. Finally, if any discrepancies or omissions are found, communicate clearly with the parties involved to obtain the necessary corrections or additional documentation before proceeding with any registration or transfer. This structured process ensures legal compliance and protects all parties. Question 15. The efficiency study reveals that a horse breeder in Alabama is preparing to sell a seasoned show jumper. The breeder is aware that the horse has a history of mild lameness in its left hind leg, which has been managed with specific shoeing and occasional rest, but has never prevented the horse from competing. The breeder is also aware that this condition is not visually apparent to a casual observer. What is the most legally compliant and ethically sound approach for the breeder to take regarding disclosure to a potential buyer in Alabama? Option A. Include a standard as-is clause in the bill of sale and make no specific mention of the horse's past lameness. Option B. Only disclose the lameness if the buyer specifically asks about the horse's leg health or any past injuries. Option C. Provide a detailed written disclosure statement to the prospective buyer before the final sale agreement, outlining the horse's history of mild lameness, the management plan, and confirming it has not prevented competition. Option D. Verbally inform the buyer about the lameness during a pre-sale inspection, assuming the buyer appears experienced with horses. The correct answer is C. Provide a detailed written disclosure statement to the prospective buyer before the final sale agreement, outlining the horse's history of mild lameness, the management plan, and confirming it has not prevented competition. Explanation. The efficiency study reveals a common challenge in equine sales within Alabama, ensuring that all legally mandated disclosures are made to potential buyers, particularly concerning the horse's health and history. This scenario is professionally challenging because a seller, even with good intentions, might overlook specific disclosure requirements under Alabama law, leading to potential legal disputes, financial penalties, and damage to their reputation. The complexity arises from the need to balance a seller's desire to complete a sale efficiently with the buyer's right to receive accurate and complete information. Careful judgment is required to navigate these legal obligations proactively. The approach that represents best professional practice involves proactively providing a written disclosure statement that details any known past or present health conditions, injuries, or behavioral issues of the horse. This statement should be signed by the seller and provided to the buyer before the final sale agreement is executed. This is correct because Alabama law, while not having a single comprehensive equine sales statute, operates under general principles of contract law and fraud. Sellers have a duty to disclose material facts that are not readily observable by the buyer and that could influence the buyer's decision. Failing to disclose known significant issues can be construed as misrepresentation or concealment, leading to rescission of the sale or damages. A comprehensive written disclosure mitigates risk for both parties by establishing a clear record of what was communicated. An approach that involves verbally informing the buyer about any known issues, assuming the buyer seems knowledgeable, is professionally unacceptable. This is ethically and legally flawed because verbal assurances are difficult to prove and can be easily misunderstood or forgotten. Alabama contract law generally requires material terms to be in writing to be enforceable and to prevent disputes. Relying solely on verbal communication leaves the seller vulnerable to claims of misrepresentation if the buyer later asserts they were not fully informed of critical details. Another professionally unacceptable approach is to only disclose issues if directly asked by the buyer. This fails to meet the seller's affirmative duty to disclose material facts that are not obvious. Alabama law, through general principles of fraud and misrepresentation, places the onus on the seller to volunteer information about significant known defects that could affect the horse's value or suitability for the buyer's intended purpose. Waiting for a direct question shifts the burden unfairly and can be seen as an attempt to conceal information. Finally, an approach that involves providing a generic bill of sale without any specific mention of the horse's health or history and relying on an as-is clause is also professionally unacceptable. While as-is clauses can disclaim certain warranties, they generally do not protect a seller from liability for fraud or intentional misrepresentation. In Alabama, an as-is clause will not shield a seller if they actively concealed a known defect or made false statements about the horse's condition. A comprehensive disclosure is a more robust protection and aligns with ethical selling practices. Professionals should adopt a decision-making framework that prioritizes transparency and legal compliance. This involves understanding the specific disclosure obligations under Alabama law for equine sales, even if they are derived from broader contract and fraud principles. Before any sale, sellers should meticulously document all known material facts about the horse's health, temperament, and history. This information should be presented in a clear, written disclosure statement provided to the buyer well in advance of the final agreement. This proactive approach not only fulfills legal requirements, but also builds trust and reduces the likelihood of future disputes. Question 16. The audit findings indicate that a veterinary practice in Alabama has failed to file Alabama equine breeding certificates for several mares bred during the past breeding season. The practice owner, a licensed veterinarian, is concerned about potential regulatory violations. Which of the following actions best addresses this compliance issue? Option A. Backdate the Alabama equine breeding certificates to appear as if they were filed on time, without verifying the exact breeding dates. Option B. Discard the incomplete breeding records and inform the client that new records will need to be created from scratch for future breeding seasons. Option C. Immediately prepare and file the Alabama equine breeding certificates for all affected mares, ensuring all information is accurate and reflects the actual breeding events. Option D. Advise the client that the records are incomplete and suggest they contact the Alabama Department of Agriculture and Industries directly to resolve the issue. Correct answer is C. Immediately prepare and file the Alabama equine breeding certificates for all affected mares, ensuring all information is accurate and reflects the actual breeding events. Explanation. The audit findings indicate a potential lapse in regulatory compliance concerning equine breeding records in Alabama. This scenario is professionally challenging because it requires a thorough understanding of Alabama's specific equine breeding laws and regulations, particularly regarding the documentation and reporting of reproductive events. The veterinarian must balance the immediate needs of the client with the legal obligations to maintain accurate and accessible records, which are crucial for traceability, disease control, and potential legal disputes. Careful judgment is required to ensure that all actions taken are compliant and ethically sound. The correct approach involves immediately rectifying the record-keeping deficiencies by creating and filing the required Alabama equine breeding certificates for all relevant breeding activities. This approach is correct because Alabama law, specifically the Alabama Equine Promotion Act, ALA, Code Section 2-15-1 et sec., and related administrative rules, mandates the accurate and timely recording of breeding information. These certificates serve as official documentation of breeding events, sire identification, and mare status, which are essential for maintaining the integrity of equine pedigrees and for regulatory oversight. Promptly filing these certificates ensures compliance with the statutory requirements for record keeping and reporting, thereby mitigating any potential penalties or legal ramifications. An incorrect approach would be to simply inform the client that the records are incomplete and suggest they address it themselves without taking further action. This is professionally unacceptable because it abdicates the veterinarian's responsibility to ensure compliance with state regulations. While client communication is important, the veterinarian has a professional and legal duty to ensure that the required documentation is properly completed and filed. Another incorrect approach would be to backdate the certificates without actually verifying the breeding dates and sire information. This is ethically and legally problematic as it constitutes falsification of records, which can have severe consequences, including disciplinary action by the Alabama State Veterinary Medical Board and potential legal liability. A further incorrect approach would be to discard the incomplete records and start anew, claiming the previous information was unreliable. This is unacceptable as it involves the destruction of potentially relevant documentation and fails to address the underlying compliance issue. Alabama law requires the maintenance of accurate breeding records, and simply discarding them does not absolve the veterinarian or the client of their responsibilities. Professionals should employ a decision-making framework that prioritizes regulatory compliance and ethical conduct. This involves 1. Identifying the specific legal and regulatory requirements applicable to the situation, in this case, Alabama equine breeding laws. 2. Assessing the current situation against these requirements to identify any discrepancies or deficiencies. 3. Developing a plan of action that directly addresses the identified issues in a compliant and ethical manner. 4. Communicating clearly with the client about the requirements and the necessary steps to achieve compliance. 5. Documenting all actions taken and communications with the client. Question 17. System analysis indicates that a horse owner in Alabama is seeking to enter into a breeding contract with a stallion owner. What is the most legally sound and professionally responsible approach to ensure the contract is enforceable and protects both parties' interests under Alabama law? Option A. Include broad, subjective clauses such as satisfaction guaranteed and best efforts will be applied, without further definition or specific performance metrics. Option B. Draft a comprehensive written contract that clearly outlines all terms, including mare and stallion suitability, breeding procedures, financial arrangements, pregnancy guarantees, and contingency plans, ensuring it is compliant with Alabama equine and contract law. Option C. Proceed with a verbal agreement for the breeding arrangement, relying on the parties' mutual understanding and trust for the key terms. Option D. Utilize a standard, non-equine specific contract template found online, and make minimal modifications to suit the breeding scenario. The correct answer is B. Draft a comprehensive written contract that clearly outlines all terms, including mare and stallion suitability, breeding procedures, financial arrangements, pregnancy guarantees, and contingency plans, ensuring it is compliant with Alabama equine and contract law. Explanation. Scenario analysis. This scenario is professionally challenging because it involves navigating the legal intricacies of equine breeding contracts within Alabama, specifically concerning the enforceability of clauses that deviate from standard practices or potentially mislead parties. Ensuring compliance with Alabama equine law and general contract principles requires careful attention to detail, clear communication, and an understanding of what constitutes a legally sound agreement. The potential for disputes arising from ambiguous or unfair terms necessitates a proactive and legally informed approach. Correct approach analysis. The best professional approach involves drafting a breeding contract that is clear, unambiguous and explicitly addresses all material terms, including the mare's health, the stallion's suitability, the breeding process, financial obligations, and contingency plans for non-pregnancy or foaling complications. This approach is correct because it aligns with Alabama contract law principles, which require mutual assent and consideration for a valid contract. Furthermore, it adheres to the ethical obligation of professionals to ensure fair dealing and transparency, minimizing the risk of future disputes. Specific clauses regarding the mare's veterinary clearance, the stallion owner's responsibilities, and the division of risks and rewards are crucial for enforceability and to prevent misunderstandings under Alabama law. Incorrect approaches analysis. Relying on a verbal agreement for key aspects of the breeding arrangement is professionally unacceptable. Alabama law, like most jurisdictions, favors written contracts for significant transactions to provide clear evidence of the parties' intentions and obligations. Verbal agreements are notoriously difficult to prove and are susceptible to misinterpretation or outright denial, leaving both parties vulnerable. Using a generic, non-equine-specific contract template without customization for the particular breeding arrangement in Alabama law is also professionally unsound. Such templates may not address the unique considerations of equine breeding, such as specific veterinary requirements, pregnancy guarantees, or liability for injury during the breeding process, and may not comply with Alabama's specific legal nuances regarding such contracts, including vague or overly broad clauses regarding satisfaction or best efforts. Without defining these terms in the context of the breeding process creates ambiguity. While parties may intend to act in good faith, the lack of specific, measurable criteria makes these clauses difficult to enforce and opens the door to subjective interpretations and disputes, which is contrary to the principles of clear contractual obligations required under Alabama law. Professional reasoning. Professionals should always prioritize clear, written agreements that are tailored to the specific transaction and jurisdiction. A thorough understanding of relevant state laws, such as Alabama equine and contract law, is essential. Before finalizing any contract, professionals should engage in open communication with all parties to ensure mutual understanding of all terms and conditions. When in doubt, seeking legal counsel to review or draft contracts is a prudent step to ensure enforceability and mitigate risk. Question 18. The audit findings indicate a recent equine sale transaction in Alabama where the seller provided a verbal assurance of the horse's health, but did not include any specific warranty or disclaimer in a written bill of sale. The buyer is now claiming the horse has a pre-existing condition that was not disclosed. Which of the following approaches best reflects regulatory compliance and professional practice in Alabama for equine sales and transfers? Option A. Since the bill of sale did not explicitly exclude warranties, the seller is automatically deemed to have provided a warranty of soundness for the equine, regardless of any verbal statements. Option B. The seller should have provided a comprehensive written bill of sale that clearly outlined the terms of the sale, including any warranties or disclaimers regarding the horse's condition, and ensured all known material defects were disclosed in writing. Option C. The buyer is solely responsible for conducting a thorough pre-purchase examination, and the seller has no obligation to disclose any conditions unless specifically asked about them. Option D. The seller's verbal assurance of the horse's health, coupled with the absence of a written disclaimer, implies a warranty of soundness under Alabama law, and the seller is liable for the pre-existing condition. The correct answer is B. The seller should have provided a comprehensive written bill of sale that clearly outlined the terms of the sale, including any warranties or disclaimers regarding the horse's condition, and ensured all known material defects were disclosed in writing. Explanation. This scenario is professionally challenging because it involves a significant financial transaction with potential for disputes regarding the horse's condition and ownership. Ensuring compliance with Alabama equine sales and transfer laws is paramount to protect both the buyer and seller, and to prevent future legal complications. The core of the challenge lies in accurately documenting the transfer of ownership and disclosing any known material defects of the equine. The best professional approach involves meticulously documenting the sale and transfer of ownership in writing, ensuring all legally required disclosures are made, and obtaining a signed bill of sale that clearly outlines the terms of the agreement, including the horse's identification, sale price, and any warranties or disclaimers. This aligns with Alabama's general contract principles and the specific requirements for equine sales, which often necessitate clear written agreements to avoid ambiguity. Such documentation provides a clear record of the transaction, mitigating the risk of future disputes over ownership, condition, or payment. An incorrect approach would be to rely solely on a verbal agreement for the sale and transfer. This is professionally unacceptable because Alabama law, while not always mandating written contracts for all sales, strongly favors written documentation for significant transactions like equine sales to prevent misunderstandings and provide evidence of terms. A verbal agreement leaves both parties vulnerable to differing recollections of the agreement specifics, potentially leading to costly litigation. Another incorrect approach is to fail to disclose known, material defects of the equine, such as a pre-existing injury or illness that could affect its performance or health. Alabama law, under principles of fraud and misrepresentation, requires sellers to disclose known material defects that are not readily apparent to the buyer. Concealing such information is unethical and can lead to legal liability for the seller, including rescission of the sale and damages. Finally, an incorrect approach would be to transfer ownership without a clear bill of sale or proper identification of the equine. This creates a significant risk of title disputes and makes it difficult to prove legal ownership. Alabama statutes governing livestock transfers emphasize clear identification and documentation to ensure lawful ownership and prevent issues like theft or unauthorized sales. Professionals should employ a decision-making framework that prioritizes clear, written documentation for all equine sales and transfers. This framework involves 1. Identifying all legally required disclosures under Alabama law for equine sales. 2. Drafting a comprehensive bill of sale that accurately reflects the agreement and includes all necessary information. 3. Ensuring the buyer understands and acknowledges all disclosures and terms. 4. Retaining copies of all documentation for a reasonable period. This systematic approach ensures regulatory compliance and fosters ethical business practices. Question 19. Benchmark analysis indicates that a horse buyer in Alabama is alleging misrepresentation regarding the horse's temperament and training, leading to a dispute over the purchase price. The parties did not execute a formal written contract, but a verbal agreement for the sale was made. What is the most professionally sound and legally advisable approach for the seller to resolve this dispute? Option A. Offer a minimal refund that is significantly less than the alleged value discrepancy, contingent on the buyer signing a broad release of all claims. Option B. Propose engaging in mediation or arbitration to reach a mutually agreeable settlement. Option C. Immediately cease all communication with the buyer and await potential legal action. Option D. Threaten the buyer with legal action for defamation if they do not withdraw their claims. The correct answer is B. Propose engaging in mediation or arbitration to reach a mutually agreeable settlement. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a dispute over a significant financial transaction related to a horse, where the buyer claims the animal was misrepresented. The challenge lies in navigating the contractual obligations and potential legal recourse under Alabama law, balancing the interests of both parties while adhering to ethical and regulatory standards for equine professionals. The lack of a written contract exacerbates the difficulty, necessitating a reliance on common law principles and potentially Alabama's specific equine-related statutes or case law regarding implied warranties or fraud. Correct approach analysis. The best professional approach involves seeking a mutually agreeable resolution through mediation or arbitration, as stipulated or implied by the nature of their agreement, and Alabama's general contract dispute resolution mechanisms. This approach is correct because it prioritizes efficient, cost-effective, and less adversarial means of resolving the dispute, which is often favored in contractual disagreements. Alabama law, while not having extensive specific equine contract dispute resolution statutes, generally encourages parties to attempt amicable settlements before resorting to litigation. Engaging a neutral third party helps maintain professional relationships and avoids the lengthy and expensive process of a court battle, aligning with ethical considerations of fairness and good faith in business dealings. Incorrect approaches analysis. One incorrect approach is to immediately threaten legal action without attempting any form of negotiation or alternative dispute resolution. This is professionally unacceptable as it escalates the conflict unnecessarily and disregards the potential for a mutually beneficial agreement. Ethically, it demonstrates a lack of good faith and a failure to explore less confrontational avenues, which can damage professional reputation. Another incorrect approach is to ignore the buyer's claims and refuse to engage in any discussion or offer a resolution. This is a direct violation of basic contractual principles and ethical conduct. Alabama law would likely view such an action as a failure to uphold implied duties of good faith and fair dealing, potentially leading to a judgment against the seller if the buyer pursues legal remedies. A third incorrect approach is to offer a settlement that is clearly unreasonable or coercive, such as demanding a significant portion of the horse's value as a restocking fee without any contractual basis. This is unethical and potentially illegal, as it exploits the buyer's vulnerability and attempts to extract unfair concessions. Such actions could expose the seller to claims of bad faith bargaining and further legal repercussions. Professional reasoning. Professionals facing such disputes should first review any existing documentation, even if informal. They should then attempt direct, good faith communication with the other party to understand their concerns and explore potential compromises. If direct communication fails, engaging a neutral mediator or arbitrator, as often encouraged by contract law principles, is the next logical step. This process allows for a structured discussion facilitated by an impartial third party, aiming for a resolution that respects the rights and obligations of both parties under Alabama law. Question 20. The audit findings indicate that a written contract for the sale of a registered quarter horse mare in Alabama stipulated a purchase price of $15,000 with a $3,000 deposit paid upon signing. The contract specified delivery within 60 days. However, the seller failed to deliver the mare for 90 days, and during this period, the market value of comparable mares in Alabama increased from $14,000 to $17,000. The buyer incurred $500 in additional boarding fees due to the delay. What is the maximum amount of compensatory damages the buyer can claim from the seller under Alabama law? Option A, $4,000, calculated as the difference between the contract price, $15,000, and the market value at the time of agreed delivery, $14,000, plus the additional boarding fees, $500. Option B, $2,000, representing the difference between the contract price, $15,000, and the market value at the time of actual delivery, $17,000. Option C, $3,000, representing the full amount of the deposit paid. Option D, $3,500, calculated as the difference between the contract price, $15,000, and the market value at the time of agreed delivery, $14,000, plus the additional boarding fees, $500, less the deposit paid, $3,000. Correct answer is D, $3,500, calculated as the difference between the contract price, $15,000, and the market value at the time of agreed delivery, $14,000, plus the additional boarding fees, $500, less the deposit paid, $3,000. Explanation. The audit findings indicate a potential breach of contract related to the sale of a horse in Alabama, specifically concerning the agreed-upon purchase price and the delivery timeline. This scenario is professionally challenging because it requires a precise calculation of damages based on contract terms and market realities, while also adhering to Alabama's legal framework for equine transactions and contract disputes. Miscalculating damages or misinterpreting contractual obligations can lead to significant financial and legal repercussions for all parties involved. The best professional approach involves a thorough review of the written sales contract, identifying all stipulated terms regarding the purchase price, payment schedule, and delivery date. It also necessitates an objective assessment of the horse's market value at the time of the agreed-upon delivery, using comparable sales data or professional appraisals. Damages should then be calculated as the difference between the contract price and the market value at the time of breach, plus any demonstrable consequential losses directly attributable to the delay, such as boarding fees or lost breeding opportunities, as permitted by Alabama contract law. This method aligns with Alabama's principles of contract damages, aiming to place the non-breaching party in the position they would have occupied had the contract been fulfilled. An incorrect approach would be to solely rely on the initial deposit as the measure of damages. This fails to account for the potential difference between the contract price and the horse's actual market value at the time of delivery, which could be higher or lower than the contract price. Alabama contract law generally seeks to compensate for the full loss, not just a partial recovery based on an initial payment. Another incorrect approach is to demand the full contract price without accounting for the horse's market value at the time of delivery, especially if the market value has decreased. This could result in a windfall for the seller and is not consistent with the principle of making the injured party whole. Alabama courts would likely scrutinize such a demand to ensure it reflects actual damages. A further incorrect approach is to ignore the contractual delivery date and only consider the current market value of the horse. The delay in delivery is a specific breach that may have incurred additional, quantifiable damages beyond the mere difference in market value, such as costs associated with extended care or lost income opportunities. Alabama law allows for recovery of foreseeable consequential damages resulting from a breach. Professionals should employ a systematic decision-making process. First, meticulously examine the contract for all relevant clauses. Second, gather objective evidence of market value and any consequential losses. Third, apply Alabama's contract law principles to calculate damages, ensuring they are compensatory and not punitive. Finally, communicate findings clearly and transparently to all parties, recommending a resolution that is legally sound and equitable.